Hello, my name is John Snow, and I'm an attorney in Salt Lake City, Utah. I also am licensed in Nevada, and I'm with a firm that conveniently has offices in Utah, Nevada, Idaho, and Montana. The firm name is Parsons, Bailey, and Latimer. And one of the things that I do for a living is I represent lawyers in connection with malpractice claims. I also represent lawyers in connection with administrative claims where they're being sanctioned for violations of a rule. And I happen to be chair of the Ethics Advisory Opinion Committee in Utah. So I have some practical as well as theoretical knowledge of the rules of professional conduct. So I hope I can provide some insight that will be positive for you in discussing some of the ethical issues that litigators encounter. There are a lot of general rules that apply to litigators, obviously, like the obligations of confidentiality and conflicts and things of that nature. But there's a specific section of the rules of professional conduct, and it's Article 3, that deals specifically with litigators. Now, I'm going to touch on a couple of the generalized rules, and then we'll talk more specifically about the rules that are applicable to just litigation matters or other type of adjudicative proceedings. The other thing that I wanted to mention is that you can't talk about ethics without also talking about substantive law and procedure. And as a result, not only will we be talking directly about ethics, but the application of ethics to a specific rules, substantive rules, and practices that lawyers do engage in. The first rule that I want to bring to your attention is competence and meritorious claims. Now, competence is a general rule contained in 1.1, and it provides simply that a lawyer shall provide competent representation to a client. And it's defined to include the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. One of the issues that we have as lawyers is sometimes we get overworked and we really aren't prepared to do certain things. For example, instead of attending a deposition, you decide to write a brief and you send an associate to the deposition. Well, in most instances, that is not going to be an issue. But when you send somebody to a deposition on your behalf, you need to make sure they're competent to handle the matter, that they know the issues, that they will make appropriate objections, as limited as they may be during a deposition, and that they know where the issues are going so that they can cross-examine a witness in order to preserve or obtain information regarding a defense or claim in the litigation. I think that's one of the things that lawyers do commonly is they get busy and they assign something to someone else without worrying about whether that other lawyer is really up to speed sufficiently to provide competent representation. Another issue with competent representation is we're required to have average skill. That rule requires average skill knowledge for the lawyer. When you delve into a new area of law, sometimes you spend time reading into it just to get up to speed. For example, if you've never handled a trust and estates matter and you really don't even know how it works and you haven't had trust and estates since law school and it's now 25 years later, you may be spending time trying to get up to speed. Question yourself on whether or not you should be billing your time for that ethically. Because you have an obligation of a minimum obligation of competence. And if you're spending time for a client to get that level of competence that is expected or anticipated, then perhaps it's not a reasonable fee under Rule 1.5, which provides that all fees shall be reasonable. And case law talks about the fact that if you're doing clerical work or something that does not really require legal skill or reading into a subject that you know nothing about, it may not be considered something that would be deemed reasonable under the ethics rule 1.5.